matter of Newron Pharmaceuticals SE and the Comptroller-General of Patents, Trademarks and Design.
Yes, Mr. Davis.
Yes, good morning, my lords. I appear on behalf of the appellant, Newron Pharmaceuticals. My learned friend, Dr Barron, appears on behalf of the controller. Your lordship should have had bundles in this together with skeleton
Yes.
arguments.
We've read the skeletons and the judge's judgment.
I'm much obliged. I do intend to take things in the same order as my skeleton, but effectively, if I'm either preaching to the converted or telling you something you've already read, hurrying along. So I'm going to start off with the background. That will include the scheme of, I beg your pardon, my lord. That will include the scheme of the supplementary protection certificates and marketing authorisations. I'm then going to pitch straight into the approach taken to Article 3B, talk about both the law and in particular YADA, and then the facts. And only then am I finally going to get to where I say the judges erred first time around and look at the European cases and finally and fairly briefly pick up on just one point, I think, the respondents' take and the respondents' notice points. So starting off perhaps with the judgment and what we can agree, because that gives an agreed background. So that's tab 8 of the bundle, core bundle I should say. And as recorded in the judgment, first instance decision of Dr Cullen, the Deputy Director, also coincidentally the hearing officer on the YADA decision, refused. Basic patent, claim 1 of the basic patent is a combination claim effectively to sulfonamide combination with levodopa/PDI for the preparation of medicament as a combined product for simultaneous, separated or sequential use for the treatment of Parkinson's disease. The fact that the therapeutic use, i.e. the treatment of Parkinson's, is in the claim is effectively not really relevant to the matters before you today. Paragraph 3 of the judgment, he explains what PDI stands for and why its method of action, how it works. And paragraph 4, that we accept that use of levodopa with a PDI was already known as a treatment. And that's certainly the case because the patent in suit is effectively to an add-on therapy to that treatment. Paragraph 5, hearing officer found that claim 1 refers to the combination of all 3, and this is the product that is protected by the basic patent. That's not in dispute, so throughout this case, we can all agree that the product in this particular case is the combination of the 3. Goes on to note then that Article 3A, and we'll come to what that is in a moment, isn't an issue, although remains relevant, and 3C and 3D are not relevant either. Just pausing very briefly on 3D, effectively 3B requires you to look at whether the marketing authorization authorizes the product. 3D moves on to whether it is the first marketing authorization. In this particular case, it is, because sulfonamide in any form wasn't on the marketplace prior to the marketing authorization we rely upon. So 3D effectively, which is a feature in so many cases, goes away in this case. And then at paragraph 7, that's the last paragraph of the judgment I'm going to take you to, effectively the judge sets out why we lost before the patent office. Effectively held that the marketing authorization did not cover the product, either sulfonamide in combination with levodopa and or a PDI. That last point is a fairly minor one that I can deal with quite quickly when I get to it. So
can I just go back to the claim I set out in?
Yes.
In combination with levodopa / PDI,
Yes.
the judge upholding or hearing officer finds that the product is a combination of 3 active ingredients.
Yes.
So that means that one reads the slash as meaning and rather than and or. Is that right?
Yes. Yes. Yeah.
It may not matter, but is PDI really an active ingredient?
I don't think it is, no. PDI is what allows the levodopa to be active before it is. But
that comes out in the wash. Either it is, in which case both the patent and the MA refer to it, or it's not, in which case it's back to just the levodopa and sulfonamide.
I haven't argued it in that way, but it is a way of arguing it. Effectively, the fact that PDI has made it into the claim is a sort of last little hurdle to get over. What the hearing officer found as a fact is what was authorised, in its broadest sense, was both sulfonamide in combination with levodopa and sulfonamide in combination with levodopa, additionally a PDI. And all we say on that is, well, he found as a fact that the marketing authorisation included sulfonamide in combination with levodopa / PDI. The fact that it also authorised other things as well doesn't matter.
Is it a fact or is it a question of interpretation? You want us to interpret the marketing authorisation, don't you?
He held that it. I probably put it too high, saying he found as a fact. He held that the marketing authorisation and the summary of product characteristics related to the use of sulfonamide with levodopa as a combination therapy to levodopa, but he basically said that doesn't matter when you look at the test under 3B, because the fact that it was what's in the summary of product characteristics as the way you've got to use it doesn't factor in. So I don't think I don't quarrel. I don't think I can with what the hearing officer found as facts. I do quarrel as to what the legal significance of those facts are.
Right.
If I can pick up my skeleton and I'll sort of skim through it, starting from paragraph 4. Then I set out the background to supplementary protection certificates, and I anticipate your lordships have done your homework on that. But effectively, the background of supplementary protection certificates, just to slightly labour the point, is to give patentees adequate protection in order to extend the life of their patents that they would not otherwise have, because they've had insufficient period of exclusivity to work their patents because they haven't been able to put their products on the market. Now, I can't and I don't make the argument that any one who's entitled to a patent monopoly must be also entitled to supplementary protection monopoly on top of that on the basis of this reasoning, because that plainly isn't the law, at least at present. The CJU have made that very clear, that not every patent deserves, for some reason, balancing exercise, this additional period of protection. But what I do say the CJU have done is when one looks at, well, what types of patent don't deserve this extra period, one should err on the side of they are entitled to the period unless they're not, if I can put it that way. And I'll come to why I say that comes out of some of the recitals in a moment. Now, I have to accept that the line of case law that we went through at first instance, which I'm hoping to go through pretty quickly today, says that when one is talking about second therapeutic indication, that is something for which one can get a patent, but not something for which one can get an SPC. Also, when one is talking about a second formulation, again, that is something for which one can get a patent, but which one can't get an SPC for. And I'll dig out the cases in a moment. However, there is no jurisprudence that says when one is talking about an add-on therapy, because that's what these class of things are, i.e. a combination patent that doesn't require the two actives to be in the same pill, let's put it that way. There's no jurisprudence currently that says you can't get an SPC for that. And I say that the court ought to be cautious in extending the law to cover that. Perhaps I can move on, because I've slightly gone off-piste. But picking it up at paragraph 7 of my skeleton,
Yes.
I go through the recitals. The majority of the ones I cite are the same as my learned friend. He takes a couple of others, but I'm not convinced they're relevant, but he can take us to them if he thinks they are. So we start off, well, actually, let's turn to tab 19, and that way we can go through them all, and then Dr. Barron won't have to take you through them again. And it's at tab 9. I say it's at tab 19 of the bundle, which is strange because I've only got 15 tabs. It's the back of the bundle.
15, I think.
Tab 15, yes. So we've got the recitals, page 296. The first recital just makes clear that the council regulation has been changed in a substantive manner a number of times in order to clarify and make it more rational. I only just squirrel that away to say perhaps a bit of caution on the travaux préparatoire that my little friend relies upon, because they were some 20 years earlier, and of course things have changed. The second recital, pharmaceutical research, decisive role, continuing improvement. Perhaps I can just ask you to read 3, 4 and 5, all of which is cited in my skeleton. And then perhaps skim 6, 7, 8, because they're really to do with European harmonisation, which is rather less of a feature than it once was. But I, in particular, read 9 and 10. Now, what I really get from that is that it's not quite a balancing exercise with putting everything in the scales one side and another. I say fundamentally this favours the innovator with appropriate safeguards. And that again really picks up on the point I made earlier, that one should be entitled to an SPC in addition to one's patent unless one shouldn't, rather than, well, it's a balancing exercise and some you do, some you don't. So moving on then.
So I'm not sure what you mean by a balancing exercise.
Well,
whatever the balance is, it's been struck by the regulation.
Whatever the balance is, it's been struck by the regulation. But I understood to some extent the argument from the other side to be it's neutral as to whether or not one should be able to get a supplementary protection certificate over and above one's patent. And indeed, the court ought to be very cautious about giving a supplementary protection certificate over and above the protection of a patent. And I think that to some extent comes into and was rejected in the by the CJU in the Medeva case. It's only I'm not pushing at this door hard, but what I'm saying is that the starting point is that fundamentally patents are a good thing.
Well, yes, I mean,
you can argue about
the point of this.
Yes,
is to give adequate protection to
Yes.
patentees who have invested in pharmaceutical research.
yes, yes.
Yeah.
All right, I'll move on. I think we're arguing about a point of nuance, perhaps. But going on then, paragraph 8 of my skeleton. I set out Article 3, which is non-controversial and is sort of recited in all of them. And then Article 1, the definition of product. I'm sorry, I'm taking them in the wrong order. And perhaps just lingering just for a moment, that of course it is anticipated that an active ingredient or combination of active ingredients can be the product.
Yeah, well, that's also clear from the definition of medicinal product.
Indeed, indeed. What I go on at paragraph 10 of my skeleton, and it is a point I've already taken, is that clearly there are exceptions to supplementary protection certificates. One exclusion is the second therapeutic indication, and that one gets from the Yism and Santen case that I'll come to. The second is different formulations of the same active, and that one gets from MIT, Yism again, and Abrexis. And then there's a further case that we'll look at very briefly, which is the Pharmacia case, which was where there was already an authorization, but it was a veterinary one, and it was held to be crossover, but that's not of perhaps enormous interest. And as I say very shortly at 12, the instant case is different, because the distinction, your lordship has the point, so I'll move on. I have in my notes to take you to the base patent, the SPC, and then the summary of product characteristics. I'm not sure that's going to be helpful or welcome, because I think your lordships clearly have the point as to what the base patent covers, let's put it that way, the claim. Your lordships have the claim in mind. I think your lordships also have the point that there's no dispute that the supplementary protection certificate is also to the combination. Perhaps I will take you to
I thought that was the issue.
No, the application.
Oh, the application.
The
yes.
application says
Yes.
says that.
Yes, indeed.
And I will take you, I think, early stage to the summary of product characteristics, which is in the core. No, it's not. It's in the supplementary bundle, tab 3, page.
Have you finished with the regulations for the time
I
being?
beg your pardon. Yes, I have. And I should perhaps, for completeness, take you to the tab 2 of the marketing authorization first. And page 21, Article 1, the marketing authorization is granted for sulfonamide, the characteristics of which are summarised in Annex 1 of the decision. So I take the point against myself quite clearly. Article 1 only says sulfonamide, but it's qualified by the characteristics in Annex 1, which is what we'll come to. So Annex 1 is at tab 3, and picking that up at page 23, and it's really section 4, clinical particulars, and 4.1, therapeutic indication. Xadago, which is the name for sulfonamide, is indicated for the treatment of adult patients with idiopathic Parkinson's disease as an add-on therapy to a stable dose of levodopa alone or in combination with other PD medicinal products in mid to late stage fluctuating patients. And what we say is that that is, in marketing speak, effectively the same as claim 1 of the patent in patent lawyers speak. It is saying that what is authorized, what the MA holder can do, is sell sulfonamide, but for and only for this purpose as an add-on therapy.
Well, therein lies your problem, doesn't it? This is saying what you can do with the product. And the distinction has been drawn, rightly or wrongly, between what the product is and what you can do with it.
I think the answer, well, you're on perhaps the key point. I was intending a bit more softening up before I got to it. But really the answer to that is one needs to be very careful by using phrases as broad as what you can do. We say it is not the law that anything outside of the capsule that your pharmaceutical is going to be in, the drug itself, is to be entirely ignored. The case law does distinguish what it does, let's put it that way, what therapeutic indication, and the case law does distinguish between how it is provided, second formulation. But the case law does not say if you are obliged, you're authorized to use it merely as a combination, that is outside the scope of And I don't like thinking about it as a strict interpretation of product, because everyone in this room, I think, is ad idem as to what the product is. The question is really, how does one apply 3B as to what is the MA authorising to be put on the market as a medicinal product? And what the case law says is, if you're authorising it to be put on for a particular therapeutic use, that doesn't matter when one applies the 3B test. If you're authorising it to be put on in a particular formulation, that doesn't matter for the 3B test. What the case law doesn't say is, if you're authorising it only to be used in simultaneous or sequential formulation, it doesn't go that far. It hasn't been considered. Now, it may well be that that's what you decide and that it does go that far, but my job is to persuade you not to do that.
Yep.
And say that the case law doesn't currently go that far. Because what I'm appealing is a judgment from the first instance, says this is perfectly conventional application of well-established CJU case law. And my first task is to persuade you that's not the case. My second task is to persuade you that shouldn't be the case.
Yes.
I'm trying to, because this is clearly the key point that your lordships have honed in on, and I don't want to just go through my skeleton and not sort of address that. But I take perhaps I can take you then to in paragraph 19
Of the skeleton.
of my skeleton. I set out what the scheme of marketing authorizations, and one has to realise that marketing authorizations and patents are there to do different things, very different things. In particular, one is restricting the things that can be done, claiming a monopoly, saying there's areas that the general public can't do, whereas the other is permissive. And the recitals I took you to earlier make quite clear that what the SPC is trying to do is the best it can to bring these two regimes together and to try and make sense of them, one to the other. But SPCs are not the same as patents, we know that. And it would be wrong to take the approach to the SPC regime that all one does is put a patent lawyer's hat on and just ignores the way marketing authorizations, what they do as a matter of practical reality. So I set out effectively what I think perhaps I can summarize it in 2 points. Marketing authorizations, there's 2 aspects to them. One is what they allow you to do, and they allow you to market a product with a particular summary of product characteristics, the label. And lawyers have always taken the view that one looks at, whilst a physician can do what they like with them, nonetheless it's on-label use that is relevant to things such as patent infringement or whatever.
The reason it's a marketing authorization is, in fact, you could sell this chemical compound. There's nothing to stop you. It's not unlawful to sell a chemical compound.
Yeah.
What would be unlawful would be to assert that the chemical compound had some therapeutic utility as part of selling it. In other words, selling it as a drug, and that's what the marketing authorization authorizes you to do, because it says I can. Here is a pill, and I'm telling you that it has these properties.
It has these properties, but they go to, and perhaps this is my second point, they go to what it is safe and efficacious to do, because you filed your phase 3 trials, and those phase 3 trials have gone really to 2 things. Firstly, that it works, and secondly, that it's safe, and it's safe in that combination. But what, and let's take the instant case, what my clients have done in their phase 3 trials, and I think this was found as a fact, is shown that it is safe and efficacious to be used in combination, or safe to be used in combination, and efficacious to be used in combination. There is no evidence that it wasn't part of the trials that it is efficacious to be used alone. And my clients couldn't sell it for use alone, claiming that it was efficacious to be used. I take a couple of other quotes, both from the first instance hearing officer in Yada as to what marketing authorisations are, and also from the Crown and NHS Darlington, paragraph 22 of my skeleton. That case isn't in the bundle because effectively I cut and pasted the relevant bit, and we didn't need another 200 pages that I wasn't going to take you to. And as my Lord Justice Birss said, makes the point that, and perhaps I'm now at page 8 of my skeleton, 25H of the bundle, and it's the middle paragraph. The scheme of regulation doesn't regulate the way in which the products are ultimately used, because one can prescribe off-label, but it does it does define the scope, the limits of on-label use, and it is a general feature in patent law when one's looking at claims of this sort, that on-label use is at least where one looks at first. I'm being a bit careful as to how I put it, because the infringement of second medical use patents is not as tightly defined as it might be following various judgments of the Supreme Court in Warner Lambert, and 40 years after the existence of such claims, it still is an undecided legal point. So I can't assist much further on that, other than to say that what one needs, what marketing authorization, what they're concerned with, is showing safety and efficacy of on-label use. And then I set out the regulations as to what you may or may not be allowed to do. And then I get to 4 propositions at paragraph 24 of my skeleton. I can repeat them, but I think I've made my submissions on them. And paragraph 25, I take the point which I'm going to refer to again in a minute, that it's important to bear in mind, of course, that patents and SPCs are restrictive and MAs are permissive, and that in my submission does begin to feed through as to why one might take a different approach to when one construes Article 3A, product protected by basic patent, and one construes 3B, marketing authorization for the, authorizing the product be put on the market. The next section of my skeleton, starting at 26, I go through the marketing authorization in this case, and also the basis of add-on therapies anyway. I'm mindful, I think, that your lordships have the point, and going through it again is not going to assist, that the marketing authorization in this case is addressed. It is saying this is what is safe and efficacious, but whether that means it is directed to it is another matter legally. So I'm not going to go through the facts again unless you indicate you'd like me to do so.
It's up to you, Mr. Davis.
Well,
Can't run your case for you.
no, you can't, but you can indicate.
We've read the marketing
You've read it.
authorization and the sheet, the particular sheet that you've shown us, but if you want to stress anything, please do.
The only other aspect of the marketing authorization I want to stress, in addition to the a part of the summary of product characteristics that I took you to before, section 4, is later on when it talks about the phase 3 trials that were conducted, that makes clear that those trials were exclusively to the combination of safinamide and levodopa, and as held as a fat, and or optionally a PDI as well.
Yeah.
I don't think it's worth taking you to that.
Can somebody write down the page number?
The page. I'm looking at the wrong document. It's page 31 of the bundle, the pharmacological properties, and in particular clinical efficacy, which is just below the second hole punch if you're on a paper version.
Thank you.
So coming first of all to the UK law, so I'm picking it up at just give me a moment here. I've got a note to take you to. I will perhaps very briefly take you to a short portion in the Brexis decision of Miss Justice Arnold, as he then was, and this is really picking up on para 36 of my skeleton just before I get to the law.
Sorry, page 6, did you say?
It is tab 1. Page 27, which is and some of the analysis that the judge goes into on a Brexit. And the only point I really want to get out of this is that Mr. Justice Arnold certainly thought it was appropriate and or necessary to look at this portion of the summary of product characteristics in order to see how things work. And this particular case, it's not directly on point, but what the applicant was trying to get out of this was what the active ingredients were. And at paragraph 59 of the decision, Mr. Justice Arnold says it's consistent with the SPC regulation when considering whether a substance produces a pharmacological, immunological or metabolic effect of its own so as to constitute an active ingredient. It is proper to refer to the SMPC forming part of it. And then a little bit further down, after he cites some authority for that, the learned judge says, as the controller contends in the present case, the SMPC makes it plain that the active ingredient is paclitathol, and that is what Brexit calls now paclitathol. My point is that's the controller's submissions on that. My point really is that the controller in this case seems to be saying don't even bother going as far as SMPC, and this is sort of the easiest way I can say that it's a perfectly proper and sensible thing to do, to look at the clinical efficacy sections of the summary of characteristics.
Perhaps I can help my learned friend and the court with that. The controller will not be making that submission. Indeed, the hearing officer did look at the SMPC, and I won't be criticising him for doing so. I'm defending his decision.
Right.
Right. Well, I'm obliged for that. Perhaps we can move on. So I'm looking now. I'm going to move now to the Yeda case. I am, of course, aware that the High Court decision was an earlier decision of my Lord Justice Lewison, and also the Patent Office decision of Dr Cullen, but nothing to the point. I say the decision is wrong, and whether on the law, whether or not it's right or wrong on the facts is really neither here nor there. It certainly is the case, of course, in Yeda that because the appellant was riding two horses with two SPCs, that effectively they had an Article 3D issue, and they needed to express things very carefully to push it as much as they could on 3B, but not fall foul of 3D. So things were put different ways on the facts. But I'm sure your lordship will be aware that you're not reviewing the facts on Yeda, you're reviewing the law. I say three propositions out of Yeda, which I set out at paragraph 38 of my skeleton at the top of page 13. The first point I think I've already just made, to determine what is the product, the marketing authorization needs to be considered, interpreted as a whole, and that includes the annexes. Secondly, when considering the product therapeutic use, I'll pause that sentence again. When considering what is the product, the therapeutic use, what it is used to cure and alleviate, is to be excluded. And I say Yeda goes no further than that meaning of use, because that was the issue before it in that case. And thirdly, that one is only looking at the active ingredients for information. Before the hearing officer, there was very substantial debate as to whether the sulfonamide was indeed an active ingredient or merely a delivery mechanism. And on that point, he found in my favour that it was an active ingredient. So we've sort of been there, done that, and don't need to revisit it. So I pick up the Yeda decision, which is in the authorities bundle at tab 11. And picking it up at page 226, which is where the decision head note starts. The judge sets out the facts briefly in 1 and 2 before setting out the claim. And the claim in that case is effectively the combination of the monoclonal antibody, which is Abifritax, and the neoplastic agent. So similar to this case, that it's plainly a combination claim. He goes on to consider a Swiss marketing authorization that is not really of relevance, because that's not what he subsequently considered. But he goes on, we then look at the marketing authorization granted by the European Commission, the European agency, and that is set out at paragraph 7, which just lists a bits of tax characteristics summarised in Annex 1, and then the judge looks at how Annex 1 sets out the authorised use, and it's in combination with indication for various things. And he goes on and talks about dosage modifications, and effectively it's the dosage modifications that I think are relevant in this case. The judge then cites at para 11 the familiar passage from Draco that I think both myself and my learned friend take in the skeleton, and then we go through the fairly familiar provisions. Picking it up then at paragraph 17, the patentee applied for 2 SPCs. So effectively, this patentee tried to ride 2 horses. The SPC of relevance is the 0371, which is the combination SPC. There was a second one that was just to the product per se. And the judge then says at paragraph 19, to my mind, it is clear from recital 10 and from the case law that what constitutes a product is to be strictly construed. We don't have an issue with that. We are agreed with what the product is. In deciding what the product is, one must focus, as the hearing officer put it, on what it is rather than what it does. Now let's just well, I'll pause for a moment. It follows then, and citing Yissam, that the concept of product cannot include therapeutic use of an active ingredient protected by a basic patent. So all I get from that is what the judge is saying here is that therapeutic use is what I mean by what it does, and that doesn't matter. That's not something that allows you to distinguish or something to take into account when one looks at 3B. And then the judge cites Mr. Justice Jacob, as he then was, and talks about it's only the active ingredients that count. And then there's a citation from MIT. And again, I don't quarrel for that, because I say it because I'm labouring the point. I'm not trying in this case to distinguish on the basis of therapeutic use, and we haven't got any issue in this case on whether or not sulfonamide or whatever is an active ingredient, because I have a finding of the hearing officer that it was. And then the judge sort of continues at 21, but really going through that, he is looking then at the facts that aren't really relevant, consideration. What underpins this what underpins this case, is that there were different issues, and I'm obviously aware. I'm trying to depersonalise who was the judge, but the dicta of the judge needs to be taken in that context. What it does means what disease it cures, not the fact you're instructed to take it in combination with something else. That is not what is being considered, we say, in this case. I want just to take one other distinguishing point on the Yeda decision, and that is at paragraph 24. And what the judge cites what the hearing officer says about the marketing authorization here, and he says, in my view, the MA filed in support of this SPC application only provides complete information regarding the quality, safety and efficacy of one medicinal product or substance, Pharmaceuticals, and only one product or active ingredient in that substance. Now, that we say is plainly different in our case, and whether or not your lordships have looked or been persuaded by the witness statement of Ms. Tufnell, or just looked at the SMPC.
So just a minute. Are you pursuing your application to adduce that as evidence?
Yes.
Now, the recorder, as I understand it, refused to allow it in.
Yeah.
And there's no appeal against his refusal. You haven't said he was wrong.
No.
So how do we allow it in on a second appeal?
Can I continue with my submission and park that and come back to it?
If you're pursuing the application, I think you need to pursue it. If you're not pursuing the application, then we will simply ignore the statement.
Let me make the, if you would, let me make the point I'm intending to make, and then tell me if you're going to say you've got no evidence for that, and then then we'll know whether we need to get there. But I've already made the point on looking at the summary of product characteristics.
Yes.
That what is being shown in our summary of product characteristics is not that sulfonamide per se is safe and efficacious. It only goes to sulfonamide in combination with levodopa being safe and efficacious.
Well, that we either agree with on reading the material or we don't. Do we need evidence for that?
The evidence is, I would submit, useful context, but not critical to you making that finding. I think in response to a query from Lord Justice Birss earlier, I referred him to a particular portion that I hadn't taken you to. Perhaps I will take you to that.
By all means.
And then I may not need the evidence. So,
well, I think you have a problem getting the evidence in, given that the recorder refused to allow it in, and you haven't appealed against that refusal.
No, digressing very briefly. Clearly, that was a case management decision, and I'm not going to be thanked for appealing a decision of case management to let evidence in or not. We decided the better course was to revise the evidence, so it's different evidence before your lordship. It's substantially the same, but we took out 50% of it, and we made clear that the person, the deponent, understands her obligations when giving opinion evidence. And so we then applied in, I think, box 10 on the appellant's notice to put in evidence effectively afresh rather than appealing the decision.
Well, it's rather unusual to have fresh evidence on a second appeal.
Indeed.
When it plainly could have been adduced before.
Indeed. Indeed. Either mechanism of getting it before your lordships was never going to be my strongest point, but we took the view that it was better to present fresh evidence in which the difficulties had plainly been addressed, rather than a case management decision.
Right. Mr. Barron, what do you say about this?
My lord, a couple of very short points on this. We do object to this coming in. The controller typically takes a permissive attitude to these things if we're able to deal with matters, but there is a point of policy here that we're very concerned when it comes to my submissions on the substance. I'll be saying that the whole point of this is a simple system to apply, and we're concerned at the optics, frankly, of the suggestion that expert evidence is necessary. I embrace all the points that my lord has made, that this clearly could have been adduced before, and a positive decision was taken not to adduce it before the hearing officer. This is different evidence from that before the judge, in the sense it's not all of the material that was before the judge, but all the material that's here was before the judge, and he didn't let it in, and that hasn't been appealed. Finally, there's the bigger point about what this evidence actually is for. What the court's tasked with today is understanding what a term product means in the context of the law of SPCs. So insofar as my learned friend says that's determined by reference to the regulatory system, that system is a system of legal rules and it's a matter for submissions from him. It's not for an expert, a non-lawyer at that, to be telling the court how it should be making a legal interpretation of legal provisions. On the other hand, if this expert evidence isn't advanced to tell the court how it should interpret product in the sense of the SPC regulation, then it doesn't help you with the one central issue that you've got to decide. So on either basis, in my submission, it's not admissible at any level, and on a second appeal, new evidence which could have been adduced before and wasn't should certainly be excluded.
No, Mr. Davis, we're not going to allow this evidence in.
I'm obliged. If I can take you then to the passage of the summary of product characteristics that I gave the reference to, my Lord Justice Birss, but I didn't take you to, and that is tab 3 of the supplementary bundle.
Yeah, it's page
And
31.
It's page 31, it's towards the bottom, clinical efficacy, and reads as follows: the efficacy of Xadago, that's Finamide, as add-on treatment to mid to late stage Parkinson's disease patients currently receiving levodopa alone or in combination with other Parkinson's disease medications, was evaluated in 2 double-blind placebo-controlled studies. So the point I get out of that really is that the efficacy testing was the combination and the combination alone. And that becomes a factual distinction to what the hearing officer decided in Yeda, where the efficacy wasn't to the combination, the efficacy data.
Is that right?
Well, that's, I
You
think,
get that out of that paragraph in Yale? I'm not sure you do. As I understood what I'm reading in the hearing officer's decision in Yeda, the irinotecan was one of the combinations that the therapeutic indication was allowing, just as the L-DOPA in your one is allowing as part of the add-on therapy.
well, I don't want to plunge into whether there were differences in facts or whether the facts are the same, therefore the result must be the same, because none of us know the full facts in the Yeda case. I was trying to get a fairly small point that what appears to have been relied upon in Yeda is a finding that the MA filed in Yeda only comprises complete information as to the quality, safety and efficacy of one substance. And what I was then taking you to was RMA, in which the clinical efficacy is that this substance is only effective, the phase 3 trials have only been done of this substance in combination with another substance, levodopa. I'm probably re-rehearsing the same points, but perhaps I could pick up my skeleton then at paragraph 43. The 3 propositions I say I get out of data is, firstly, consider the marketing authorization as a whole.
Yeah.
Secondly, therapeutic use excluded. I might come back to that in a moment. And thirdly, consider only active ingredients. In my submission, and I'm sure my learned friend would agree, 1 and 3 are non-controversial, Two, on my submission is as far as Yada goes. It may well be that your lordships decide the law goes further. I'm going to urge you not to. But we say that Yada itself looked at the relevant CJU decisions at that time and rightly excluded therapeutic use as something that could be relied upon as a distinguishing feature when applying Article 3B. So that's as far as I get on that. Now, I want to move on now, if I may, to the Mediva decision. And that is not the easiest decision around which to navigate by a long way. I've put in a very brief responsive skeleton in which I've attempted to assist with that process. But as we understand it, in this case, we're not trying to define product, we agree what that is. In this case, what we're trying to do is apply the Article 3B question, is there a valid authorization to place that product on the market or as a medicinal product? Now, it is certainly the law that product is strictly construed, let's put it that way, that's been said enough times. And it is also the law that 3A is a narrow test, product covered by the basic patent. All sorts of arguments have been run to try and broaden that, and they've all failed. But we say what the Mediva case says is that in order to get a sensible result in this system, whilst you are applying a narrow test for 3B, that should be tempered by a broader, a teleological, I think they call it, or purposive way of applying 3B, which is precisely the provision before your lordships today. Now, I accept that Mediva is in a different context, but I do urge that the only case that we have potentially on the key provision is saying, no, don't apply strict analysis to 3B. If you do that, you don't get a sensible result. So apply a slightly more teleological test.
This is the foundation, is it, of your submission that the product differs as between Article 3A and 3B?
No, I don't know. So I don't know quite where that's come from. I think if I was trying to say you've got 4 tests in 3, if I was trying in Article 3, if I was trying to say the product in all 4 of those tests can be different, I'd get fairly short shrift.
I mean,
because
the product is a defined term.
the product is a defined
in the
term, and we all know
regulation.
what the product is.
Yeah.
The product is sulfonamide in combination with levodopa/PDI. That's what it is in this purpose. But we are then going through four tests. We're going, is that product, which we know what it is, covered by the basic patent? Yes, it is. We've done an exercising claim interpretation,
Yeah.
patent infringement law, and decided, yes, it is covered. Now when we get to 3B, we know what the product is. Is that authorised to be put on the market as a medicinal product? So I'm sticking with a consistent definition of, but I'm saying there's 4 different tests. And I'm going to the what is the marketing authorization?
Right, because the judge seems to have thought that you were arguing for differences in the product,
Yes, he does.
but that's not what you're saying.
That's not what I'm saying, and not what I believe I said down below, but the judgment is what the judgment is.
Right.
But I'm not arguing that. I've now got the unenviable task of taking you through the Mediva case in
Yes.
order to make good my proposition that whilst there's a fairly narrow view taken to 3A, product protected by basic patent, there's this broader approach, more generous approach taken to 3B, because otherwise one gets a nonsensical result. So the Mediva decision is at tab 6. Now, perhaps I could just set some context. Tab 6, page 108. Now, the context is this. Mediva have a patent. It has a claim to a combination, and we're just going to call that combination A. That particular combination doesn't matter. And it makes 5 applications for SPCs. And effectively, it's each of those SPCs is A plus something else. So it's A plus B, A plus C, A plus D, or whatever. It seeks to get supplementary protection certificates and loses both before the IPO and the Patents Court, goes to the Court of Appeal, and they refer various questions to the CJEU. The first 5 of those questions were on Article 3A, because this again was a patentee who was sort of trying to ride 2 horses. They were trying to say either the product's X, in which case I'm okay in 3A, or it's A plus B, in which case I'm okay. We're not doing that. We've decided which horse we're running. We're running the combination. So it's only question 6 that becomes relevant. Now, that is set out at the top of page 110 of the bundle in the head note. And the question is this, decoded. Does the regulation, in particular Article 3B, permit the grant of a supplementary protection certificate for a single active ingredient or a combination of active ingredients where the basic patent in force protects the single active ingredient within the meaning of 3A? What that's basically saying is, if you've decided in 3A, the product is this combination A, when you then turn to 3B, so that's the second half of question 6, the medicinal product containing the single active ingredient or combination, that's A, together with one or more active ingredients, so A plus B, is the subject of a valid authorization. So what they're looking at here is you've worked out what your product is. Your marketing authorization covers a narrower combination. A strict interpretation of Article 3B would mean that the authorized product wasn't the same, the authorized thing wasn't the same, because there's not absolute concordance. And the Advocate General, and the court upheld it, goes on to say, well, a strict interpretation of 3B would mean that you got no protection for that, and in fact no protection in that field of pharmacy. That can't be what the legislature intended, and therefore a purposive construction would suit better, and that is the one the court ought to give. That's what I get from this decision. Now, it's not in the same context, but I'm relying on the same sort of approach that add-on therapies are always going to be an addition to something that's established. If your lordships are against me, that area of medicine won't be subject to SPCs. That can't be what the legislature intended. Therefore, you ought to allow it.
In a sense, you're the other way around, though, aren't you? Your patent protects A plus B, and at any rate, on one view, the marketing authorization is for A.
Yes,
So you're the
I am the other way round.
from
I am.
Moylan.
I think that's well put. I am the other way round, which is why I say I tried to make quite clear this case is not the same on the facts. All I am trying to get out of it, because in Mediva they tried to argue it both ways as well. They tried to say, well, our product's X, in which case, and the court said, well, then you fail 3A. But if our product's Y, then you fail 3B. And in the same before your lordship in Yada, it was like we're having two goes, and the court go, it doesn't matter which go you have. You either fail A or B.
Yeah.
We
Anyway,
have.
you show us the bits that you want to.
All right. So what the court do, I'm picking it up at 112. There's an introduction at page 112, the legal context at 113.
Just to be clear, though you said the court, Mr. Davis, this is the Advocate
I
General.
do beg your pardon, I beg your lordship's pardon, this is the Advocate General. The Advocate General, it contains more reasoning. The court basically, I can't even say upholds the reasoning, because the CJU doesn't work like that. It goes in the same direction, and therefore one assumes that they were convinced by that reasoning.
And it's the same Advocate General who was advising the court in Newron.
That I hadn't spotted. I've tried to take personalities out of it. Two of you at least.
I'm taking personalities out of it, Mr. Davis. This Mediva case is one that came before what I can call the reaction to Newron.
Yes.
To the clarity that not all pharmaceutical research necessarily gets an SPC,
Yes.
whereas part of the logic of Mediva might be said to be saying, well, this is a deserving case, therefore they deserve an SPC.
Yes. I can't push back on that, because you're absolutely right.
I mean, the last word on the subject at EU level is a Senate, isn't it?
It is. I mean, I can part this decision because I've made the point.
Well, I think if you say this decision supports your point, then
I will take you through. I will take you through. I do intend to take you through the other cases, but I think your lordships have my point generally on them. That whilst they are adopting an approach that is more restrictive than, whilst they are adopting an approach that is more restrictive for SPCs than for patents, they are not binding on the particular circumstances before you today.
Right.
And that I can't go any further than that. It then almost is sort of over to your lordships to decide where the balancing exercise is, and that's why I took you earlier to the recital saying that the exercise ought to be in favour of granting SPCs when you've got patent protection, unless something tells you not to.
Yeah. All right, so we're in the Advocate General's opinion. And
we're in the Advocate General's opinion.
I think we needn't go through it all, but just pick out the key points.
Right. I'm then going to skip all the way through to page 129 of the bundle. So it's paragraph 73 of the opinion.
Yeah.
And it's really the conclusion that a literal interpretation would mean that no supplementary certificates may be granted in this particular field. And then at 74, it then goes on as my Lord Justice Birss has already pointed out, that it follows that they will examine whether such a conclusion is compatible with the aims of the regulation, and since the view is the answer is negative, they'll then complement the literal interpretation of 1 to 3 with a teleological interpretation. And I should point out paragraph 78 that makes very clear that in 78, halfway through, one needs to, in view of the complexity of the balance of interest, this point against me really, it's necessary to proceed with great caution when making a teleological interpretation of individual precisions. Nevertheless, 73, in my view, and then goes on to say that in view of the very clear result, the literal interpretation would mean that in the case of medicinal products with multiple active ingredients, only part of which, etc., can be granted, is not compatible. And we effectively say that's the same with the area of add-on therapies. I'm aware of the points pushing back on me on that, but that is what we say would again be the case. And then there's a certain amount of reasoning and reference to submissions before a conclusion of paragraph 88. Perhaps I could just ask you just to read paragraph 28. Now, paragraph 88 then has footnote 32, which is the relevance of the interpretation. And if I can ask you just to read that footnote, which refers to the Pharmaceuticals case, which it says is in favour of a broad interpretation of Article 3b. Now, before my learned friend jumps up, I haven't put the Pharmaceuticals case, I don't think is in the bundle. When one looks at that case, it doesn't use anything like words broad interpretation. It's a reasoned order and it's entirely conclusionary and takes the debate absolutely nowhere, which is why I'm not taking you to it. But that is how it has been interpreted. Insofar as this decision is concerned, that really is the best I can do.
What does the
It
court
doesn't
say?
go any further.
You better show us what the court says. This is
Well,
what the
I
Advocate
can
General
tell you what the court says. The court is paragraph 147 of the
page 147.
sorry, page 147, paragraph 29 of their judgment. And it's paragraph 30. They note the fundamental objective to ensure sufficient protection to encourage pharmaceutical research, which plays a decisive role. Perhaps my emphasis there is on the word, it's the fundamental objective. This is my point. You should be able to get SPCs unless there's some reason that you can't. And they refer to the Pharmaceuticals case. They then consider the literal interpretation before effectively concluding against it. Perhaps I can ask you to read paragraphs 35 and 36 of the decision.
So, I mean, 38, they are looking at the patent is for A, but the authorization is for A and B.
Yes.
So I've got a patent for A, and you want to sell A and B, and I can say, well, you can't do that. You're infringing my monopoly in A, aren't I? Well, that's the point they're making.
The
Whereas if you claim A plus B and I sell A, then I'm not infringing your monopoly.
if you've got a patent for A, and the product is A plus B combination, you do infringe, so it is protected by the basic patent. That's why they've got.
That's what the commissioner's saying here. That
Yes.
If you've got a patent which protects, they call it X, and you've got the product authorizes X plus Y,
Yeah.
your SPC will relate to X. That's what they're saying in this paragraph 38.
Yes.
Won't relate to X plus Y. So it's going back to what the patent protects. Now, in a case in which the patent protects X, nobody else can sell X for the 20 years of the patent. Whereas if you claim X plus Y, then selling X alone or Y alone is not going to infringe.
It's not going to infringe. Yeah.
So that's why the fact that you're the other way round from what was being considered in Mediva may itself have some legal significance.
What I get out of Mediva, I have to accept what you say because I think it's right, is that in this scenario, which is different to our scenario, they held that a narrow interpretation of 3B, looking for exact concordance between the product, the way you did the test for A and the way you did the test for B, would lead to a conclusion which meant that SPCs were not in practice available in this area of technology. That's what I get out of it. I have to accept that we're looking at a different situation. And all I say is the same rationale that if one takes the narrow interpretation of 3B, one will end up with the same arguably unacceptable result. Yeah. So I make that point as sort of my best point.
I understand.
My slightly narrower point is really to respond to my learned friend who's just screaming everything should be strict and narrow, absolutely everything about this should be strict and narrow.
Yes.
That's all I can get out of it. I hoped I made quite clear at the outset we're looking at different factual circumstances.
Yeah. Right.
I mean, one of the issues one gets, and I was discussing this outside court, is how one achieves the balancing exercise with competing interests, etc., etc., etc. And the point I made is, well, how are the judges to decide that? They're not economists who know what is more beneficial as to should these things be sold, shouldn't these things be sold, or whatever. Now, the CJU is just quite happy to decide these things on no evidence and decide what's beneficial and what is and isn't unacceptable. Your lordships adopt a more evidence approach, and neither side is going to want to put in evidence as to what is most beneficial to the marketplace, because is that the consumer, is that the NHS who has to foot the bill, is that drug innovators or whatever, which is why I've tried to focus the argument on the purpose of the regulation is you get an extension to your patent because that's seen as beneficial, unless there's a reason why you
No, I
why you
understand
shouldn't.
that. That's your submission.
That's my
We are not in the business of balancing interests in
No.
coming to decisions.
no.
The balance, as I said, has been struck by the legislature in the regulation as interpreted by the court,
Yes.
and our job is to apply the
Yes.
law as we find it.
Yeah. All right. Well, I'll go back to my skeleton. I've sort of dipped into medieval, which I put just above paragraph 45.
Right.
Paragraph 45 really through to 58 is about giving the instant marketing authorization and purpose of construction. They're really points I've made. I've taken you to the two key points, the section 4 and section 5, and I think I'd just be repeating myself if I went through those aspects of my skeleton again in detail.
Yeah, I mean, your main point's in your paragraph 51.
Yeah. What I do need to do, or either quickly or slowly, is just satisfy your lordships that the line of cases we look at, Pharmacia, MIT, Lewison, Newron, which is the outlier, Birss and Santen, are what the judge goes on to say at paragraph 60. In short, how a medicinal product is used does not form part of the identification of the product itself. I have the courts have looked at what is, narrower points of what is meant by that. Does one mean therapeutic use? Does one mean how it's formulated? Or does that mean use in combination? And I think your lordships have my point that we say the combination use is an undecided point and is not decided by any of those cases. In addition, none of those cases really contain useful reasoning to get you to the answer in my case. I will perhaps just skim through them, but that's the reason I'm skimming through them, to show two things. One, they don't cover the instant case, and two, they don't, is why I'm skimming, they don't actually have useful reasoning to allow you to get to a result today.
Right.
So it's using para 62 of my skeleton as my guide. I will take you first to the Pharmacia case, and that's at tab 8. And the scope of the question can really be picked up from the first paragraph on page, well, perhaps I can, first paragraph on page 184. And what that is saying is this, in 94, we've got Dostinex authorized in Germany, and it has a particular active ingredient, and that same active ingredient had already been authorized in, that active ingredient was first authorized in 92 in the Netherlands, but the veterinary medical product, which had the same active ingredient, was authorized some 5 years earlier in 1987. The Deutsches Patentam rejected the application, and the question referred is at page 185, paragraph 15 of the decision. And it's to do with 3D. Is it the first authorization as a medicinal product? And at 15, more precisely, it asks whether, in the case of an application for a grant of a certificate which obtained marketing authorization as a medical product, and then they say whether it was first marketed, or whether a marketing authorization for a veterinary product effectively trumps it and becomes the first marketing authorization. And the decision is at paragraph 20. It follows first, the decisive factor for the grant is not the intended use of the medicinal product, and secondly, the purpose of the protection by the certificate relates to any use of the product as a medicinal product without any distinction between use of the product as a medicinal product for human use or veterinary medicinal product. So what I get out of that is, well, I accept it. It says things like intended use. What it means by use is narrow in meaning use as a veterinary or use as a human, and that's as far as the decision goes.
Well, what they're doing, as I understand it, is they are interpreting the phrase "the product" in the context of whether it's the first marketing authorization
Yes.
for the product. And what they're saying is that the product is the active chemical, and it doesn't matter whether it's being used to treat animals or humans. It's still the same thing.
Yes.
So it was authorized, you couldn't have sold it to treat humans in 1994,
No.
but you now can use it to treat humans. But nevertheless, that's not the first marketing authorization because the active ingredient is the same active ingredient.
Yes, because the legislature, when deciding on 3B, does not distinguish as to whether or not you're going to use it for a human or whatever, or an animal. But it's not going as far as saying just look what's in the box. I mean, in my submission, it would be wrong to broaden out what this decision is trying to say any further than it makes no odds whether you're going to use it for humans or animals. The MIT decision is at tab 5. And that's, I'm just going to go through the head note, really. The referred question is right at the bottom of page 101. Does the concept of combination of active ingredients mean that the components must all be active ingredients with a therapeutic effect? And then held, head note, the only para. Article 1B had to be interpreted so as not to include the concept of combination of active ingredients, a combination of two substances, only one of which had therapeutic effects of its own for a specific indication. So really the MIT decision is not really on point at all, because we have a decision in this case that both the levodopa and the sulfonamide are active ingredients. So that decision doesn't really take us any further and or support the proposition put by the judge that the case law is as broad as any use. Yism I think effectively failed on 2 points, and that is at tab 12. And picking it up at paragraph 5, page 239. So Yism had a patent for a particular composition, and last sentence of paragraph 5, it also covered the same composition with a carrier. They applied paragraph 6. They were granted authorization covering calcitrol as an active ingredient. We'll leave to one side the formulation because it doesn't really take us anywhere. Relying upon that authorization, paragraph 7, they applied for a supplementary certificate for calcitrol. Paragraph 8, the Patent Office refused the SPC, saying it wasn't the first authorization because there were other medicinal products containing calcitriol as a sole active ingredient that's already been granted. The question referred then by the High Court is set out at paragraph 11, and it really the reference is what's meant by product in Article 1B, and in particular, does the application of therapeutic agent play any definition in product for the purposes of regulation of the regulation? And the answer to that was effectively no. One gets to that in paragraph 17. Firstly, the summary of MIT, that product must be interpreted strictly to mean active substance or active ingredient. And secondly, paragraph 18, the concept of product cannot include therapeutic use of an active ingredient protected by a basic patent. So that's really looking at saying, well, the concept of patent of product isn't therapeutic use.
And the effect of that, is this right, is that the Patent Office was right.
The effect of that is the Patent Office is right. Yeah. But really, this is, I mean, it's not an aspect where we're challenging. And I've used the language distinguish, because as a patent lawyer, that's how I think. We have to accept that the therapeutic use is not something that would allow you take into account when you're deciding what is authorized by the marketing authorization. But to put it into our particular case, our claim is limited to treatment of late Parkinson's disease. That is in our MA as well,
yeah.
But that's not something we're relying upon. We don't seek to. We can't. The case law is clear on that. But it's really, and I know I've made the point several times, really to say the established law is limited to two particular scenarios, and what the controller is asking you to do is to extend it to a third scenario.
Yeah.
And that's very different to what the judge found, which is the law already extended to that third scenario. We say you need a good reason to extend it to that third scenario in view of all the recitals, etc., etc., and therefore we're asking you not to do it.
Right.
Got ahead of myself. That was my. Back to my skeleton very briefly. I talk about Newron just for completeness, but as my learned friend says, it's been overruled, and I'm not, and I don't rely upon it. I talked briefly about Abrexis, which we looked at very, very briefly. That is a new formulation of a known active. That doesn't take us any further. So finally, I do need to take you to Santen, which is at tab 9. was going to dive straight into this, and take you to paragraph 32.
Yes.
And what it's really doing there is it's saying we need to have another look at 3D in view of what the Court of Justice has said about Newron. I move straight on then to paragraph 37, and they say in order to provide a useful answer to the referring court, it's necessary to examine whether Article 3D must be interpreted as meaning that MA must be considered to be the first MA where it covers a new therapeutic application of an active ingredient. They say in paragraphs, what had happened in Newron was that the CJU had made the definition of product for 3D as clear as mud, in that some things were and some things weren't, and nobody had a clue where the dividing line was. In 39, they say, well, you've got to go back to the concept of product and whether that is dependent on therapeutic application of the active ingredient, and in particular whether a new therapeutic application of an active ingredient may be considered to be a product distinct from a different already known therapeutic application of the same active ingredient. Putting that in the way I've liked to put it, they're basically saying, can therapeutic use distinguish for the purpose of deciding what a product is? And they go on to say, no, it can't, not in any circumstances. So Newron is wrong. And we don't really get much more from the decision than that. It doesn't take us any further, really, than the Yissam decision. Admittedly, there was a to and fro to the fact that this is limited to therapeutic use.
What do you say about 43? Which the court said in the middle sentence, something follows that the term product, the meaning of the regulation, is not dependent on the manner in which that product is used, and that the intended use of the medicinal product is not constituted.
I say yet again that this is, if I'm allowed to, this is slightly sloppy language when they're talking about use, because they're then immediately citing the Pharmacia case, which I've taken you to, and that was the one as between human and whatever. And I'm saying that when one looks at the word use in these decisions, one needs to drill down what they're really talking about, not just apply any colloquial meaning of the word use. That I would submit that it has got to be fair to say that when well, who knows, but when that statement is made by the court, they are drawing their minds as to whether or not it's human use or veterinary use by reference to the Pharmacia decision. They are just simply not addressing their minds as to whether use in combination as an add-on therapy is something within the scope of a broader legal proposition that they're trying to make. That's really it, I think, for my case. I think I've put it every which way. I don't want desperately to repeat myself too many times. I do want to make a couple of very brief points in response to the way the case is put, or one point in response to the way in which the case is put on behalf of the controller. And it's really taking issue with their paragraph 75 of their skeleton. And this picks up on the fact that marketing authorisations and SPCs and patents are different beasts and they're there to different markets and do different things. And when one is looking at a marketing authorisation, one needs to understand to what audience it is addressed. But what the controller says, 75, and it's very pithy, is properly understood. What the marketing authorization authorizes Newron to do is simply to put sulfonamide on the market. Now we just say that is not the case. That is not what we're allowed to do. We can't ship out boxes of sulfonamide. But that would be an offence within the scheme of marketing authorization. What we are authorised to do is to put sulfonamide on the market with particular instructions that it is only safe and efficacious to use by way of an add-on therapy to levodopa or PDI. And that really becomes the fundamental issue between us. But we say that is something that what one needs to almost put a sort of marketing authorization hat on, not a patent lawyer's hat. Second point in response is probably finally on the PDI point before I forget about it. In that if you're with me on there being authorization of levodopa and sulfonamide, do we fall at the last hurdle in that our authorization doesn't go as far as PDI? And we rely then on the hearing officer's finding that the marketing authorization authorizes both use, the combination of 2 and the combination of 3, because that's what's been shown to be safe and efficacious. And we merely say this: the fact that our marketing authorization authorizes other things as well doesn't matter if what it includes, it does authorize, is the combination of the 3. And the hearing officer made quite clear that it does include that. He just said, you don't need the 3rd thing. It authorizes more, but it authorizes what we need it to authorize. That's quite a short point on that.
Sorry, I don't think I've quite understood that.
Right.
So the premise is that the marketing authorization authorizes a combination of 2 or a combination of 3.
Yes.
Your patent claims a combination of 3.
Yes.
So if the marketing authorization authorizes a combination of 2 or 3, and your patent claims 3, you say that an SPC for 3 should be granted. Is that right?
Yes.
Yeah.
The interpretation of 3B doesn't say your marketing authorization authorizes the product and only the product.
I follow.
Then just a couple of points on the respondent's notice. The first is that this is all terribly complicated for the patent office to look at the summary of product, characteristics. Well, the patent office needs, as the learned recorder said, patent office needs to provide resources to do its job, and it does lots of complicated things on a daily basis. We had a very extensive debate with Dr Cullen as to the mechanism by which levodopa and sulfonamide acted and crossing blood-brain barriers, and Dr Cullen had no difficulty. The whole point of the patent office is it is tasked with specialists, and whilst my own friend might have been right on the evidence that we haven't looked at because we haven't looked at it, and or that one doesn't want to dive into particular nuances of the phase 3 studies, we say it really shouldn't be beyond the wit of the Patent Office to look at the summary of product characteristics, and that's something they routinely do. The second point was a rather complicated point on the basis of Article 14D. Article 14D is a slightly curious provision of the regulation that allows either third parties or the Patent Office of its own volition to revoke SPCs when the marketing authorization upon which it is based lapses for whatever reason. The difficulty one has with this is it's a bit of a backwater that we can't find anyone's ever used it. And we therefore, and we sort of pushed this back to the Patent Office because they brought it up in their skeleton at first instance, and we haven't had anything from them that this is actually a logistical problem in reality. It's a point I basically address in my High Court responsive skeleton, which is at tab 9 of the core bundle, page 107, and it's paragraph 14. It's really a very short point on that. We can't do any better than that. It's really up to the Patent Office to show that they simply can't cope, and this must influence your views as to the substantive issues of law. Give me a moment. We've done unless I can assist your lordships further, I think those are my submissions.
Thank you very much, Mr. Davis. Yes, Mr. Barron.
My Lords, I'm grateful. By way of a roadmap, subject to, of course, my Lord's questions, the structure I'm proposing to take is roughly as follows. First, I shall start with the explanatory memorandum, that's to say, the one piece of material travo that we have, showing what was sought to be achieved by the SPC system and the instruments that provided for it. I will then very briefly take a look at one or two key provisions of the regulation, but I'll take that very briefly because you've seen them already. Secondly, I'll go through the case law, and I am going to take some time over that, the EU case law in particular. There will be a degree of island hopping, but I'm going to try and set my Lord's mind at rest that I'm not missing anything out by the way in which I do that. That all goes particularly to the definition of product in Article 3. Third, again at some speed, I suspect I shall highlight just some of the key findings made by the hearing officer and then the judge, the latter very quickly because in large part he approved what had happened below. And then finally I'll engage with the grounds of appeal, but I expect by then to be able to do that rather shortly in the hope I've covered the ground in advance. So, my Lords, the explanatory memorandum is at tab 13 of the authorities bundle. A short point on this before we look at its detail. My learned friend said we've got to be careful because this was written 20 years ago and things have changed. The material provisions of the regulation haven't changed in any material respect, and I'll show you the Grand Chamber of the Court of Justice saying precisely that in the Santem case. When we get there, it was clear that there's been no change on product, save that if anything, in the latest regulation, the 09 regulation, that was made concrete, is the phrase they use. I've pointed to a handful of paragraphs from this in my skeleton, and I'm not going to go to them all, but that's not because I'm resiling from anything. I've said there. Let's start, if we may, on page 252 of the bundle. So paragraph 10, I'm afraid the paragraph numbers are a little faded, but paragraph 10, which is the one underneath a balanced system. So this is the point you've heard a fair bit about this morning, and I make a similar point in my skeleton at paragraph 28, that there is an idea of balance that suffuses all of what this regulation seeks to do. Now, Lord Justice Lewison is quite right to say that balance is an encoded balance, so it's not just leaving balancing acts to you, my lords, but it's all meant to be in there in the regulation. But of course, when we come to interpret the regulation, where there are competing interpretations of a provision, something that it's appropriate to have in mind is that this is seeking to achieve a fair balance between competing interests. That's relevant to the exercise we're doing today, because my learned friend says, oh no, this is all tilted very much in favour of innovators. And so, for example, we'll cover this in detail when we get to the law on it, but in effect, he says, well, the definition of product contains everything I want it to contain, unless the CJEU has dealt with a case precisely saying those facts aren't included. My lords, I say that's exactly taking things the wrong way up. The starting point is the strict definition I'm going to show you, and that logic has been read onto a series of different fact patterns, and it reads equally well, as found the hearing officer and the judge and my Lord Justice Lewison in Yedder, onto sets of facts like the present. So all I wanted to take from paragraph 10 was that idea of balance. Paragraph 11 is clear in its second sentence. It doesn't involve the proposal for the regulation granting a certificate for all medicinal products authorised to be placed on the market. So it is selective. Only one certificate may be granted for any one product, a product being understood to mean an active substance in the strict sense. So there it is, even before the regulation has been codified. The very object of setting up this system had as part of it that the product would be defined strictly. Next, 2 pages ahead to paragraph 16. And this one is one on which I place considerable reliance and did so before the judge. I alluded to it earlier when responding to my learned friend's application to adduce his late evidence. The proposal for a regulation provides for a simple, transparent system which can easily be applied by the parties concerned. And we get a bit more information in the next paragraph about who the parties concerned are to be. It therefore doesn't lead to excessive bureaucracy. There is no need for any new administrative body, and the patents offices, I stress that, should be able to implement the procedure for granting the certificate without an excessive burden being placed on their administrations. So you can see where the basis for my respondent's notice point about the burden placed on the IPO finds its basis. But another point that I extract from here is that this has to be doable by patent offices using the skills and people that patent offices have. So when my learned friend talks about putting on a patent hat or a marketing authorization hat, it's pretty clear here that the proposal was that people with patent office hats should be enough. It's not a proposal to set up a system that requires specialist regulatory lawyers or their regulatory affairs knowledge to understand and administer. So a construction of the regulation that says those things are required is prima facie unlikely. At one point in his skeleton, my learned friend refers to the skilled addressee of a marketing authorization, the skilled specialist in understanding marketing authorizations. I say there's no basis for that on 2 fronts. First of all, the skilled addressee is, of course, a concept that's imported from patents law. But in the law of patents, it has an express statutory basis because Section 3 of the Patents Act of 1977 refers to a person skilled in the art. There's no such statutory basis for my learned friend's skilled addressee of the MA, which has 3 different formulations at different places in his skeleton. And this memorandum is clear that no such person in real life was envisaged to be part of the team that would deal with these things. The third paragraph.
European law does sometimes invent characters for the purpose of legal dramas.
Yes.
We've got all sorts of different characters to
Yes.
people the stage.
Yes, indeed. But to invent a character that's precisely doing the opposite of exactly what's stated to be the purpose of this system is something that they haven't done, and I say we shouldn't be surprised by that, and we shouldn't be filling in the
I
gap.
understand. It's just that you were saying that it doesn't have a statutory basis.
Yeah,
but
well, that's yes, it's another. So there'd have to be a better reason. If it had a statutory basis, then I wouldn't be able to say anything against it. But it has no basis, so there would have to be a policy basis. As it is, the policy basis of this regulation was flat against the idea of needing to refer to regulatory affairs knowledge. The next point to extract from this, and I think the last from the memo, is the third paragraph under section 16 there. About 4 lines down is the second sentence. Examination of the conditions to be fulfilled for the certificate to be granted involves the use of objective data that are easy to verify. That becomes relevant to the sort of exercise that my learned friend is urging, the detail with which he says the regulatory materials are to be looked at, and particularly when we think about the finding the hearing officer made that PDI was only referred to a few times equivocally in the space of a set of documents. We should remember that the initial appeal bundle in this case was over 6,000 pages long. That, in my submission, is not a quest for objective data that are easy to verify. So that's the scene setting for the regulation. I'm not going to take you to all of the relevant provisions of the regulation because you've seen them. I just have 2 very short points to make. The first, so the regulation is behind tab 15. The first is simply to say that in Article 3, the references to the product are to the product in all 4 subparts of the article. So it must be the same product. It's been expressly conceded before the hearing officer and the judge, and in the skeleton for this appeal, that the product of the patent is the triple combination, if I can put it that way, sulfonamide and levodopa and the PDI. So the only way that all of these things can be satisfied for the product is if they are all satisfied for that triple product. And that's why we have the issue arising in this case that we do. My next point is about Article 8, which is over the page and sets out what must be included in the application for an SPC. It sets out some boringly inevitable things like names and addresses and so on under A. But then B is the one I want to focus on for a moment. A copy of the authorization to place the product again on the market, as referred to in Article 3B, in which the product is identified. So my learned friend's sort of spirit of the MA approach, where you look at the MA and you have a think about what, as a matter of practical reality, to use his phrase, does it allow people to do, isn't what this says at all. Here it envisages that the authorization identifies the product. And that's all I propose to do with the regulation itself. So next to the case law, the way I propose to do this is to take you through just the core holdings in some of the key cases, more or less in chronological order. I'm going to use as my guidebook for that Mr. Justice Arnold's judgment as he was then in Abraxas, simply because he's done the legwork of summarising the cases up until the date he was writing, and because the Comptroller endorses his summary as far as it goes. Since my Lord, Mr. Justice Arnold, as he was then, was dealing with those in a slightly different context, considering one question about whether particular ingredients were active ingredients, and another about Article 3D as opposed to B, I'm still going to take you to the key parts of those judgments. They're often the same ones he's drawn out, but not entirely, and I'll explain why I rely on them in the present context. But to try to give some context to that tour, I will tell you first what I say is the overall arc of the story here and what it is I'm going to seek to get from those judgments. First, inevitably, I'm saying that the definition of product in Article 3 has consistently been given a strict interpretation in the words of the CJEU, and I say that in context is plainly a narrow one. In particular, the definition of product does not include any considerations in my submission of what I will call, this is my term, the use context, and by that I mean no consideration of either the therapeutic indication, nor of how the product is to be administered, nor of what, if any, other substances that may have been taken by the patients to whom it's administered. None of that is part of it. The product is strictly that. An active ingredient.
So you say the product is the physical thing?
Yes, it's the active ingredient, indeed. Or combination of active ingredients if it is a product that has them,
Yeah.
yes. Strictly a question, as the hearing officer put it in the Yedder case, and my Lord Justice Lewison accepted in that case, a question of what the substance in question is and not of what it does. And as we'll see when we get to Santen in due course, we can now extend that and say, nor does it include consideration of how it does it. A further thing to note before I start on the tour through the authorities is that the law did go through a bit of an excursion, as my learned friend acknowledges, so we'll be able to take it quickly. Put shortly, there's a series of consistent decisions taking the narrow, strict view, and then came Newron, which frankly was flatly inconsistent with some of those earlier decisions in its logic and seemed to liberalise things as far as the definition of the product. But then we had the reference judgment in Abraxas that I've already referred to, which we won't need to turn up, I don't think, and the decision in Santen, which we certainly will. Santen, a Grand Chamber judgment, brought everything back into line and made clear that the proper interpretation was a strict one that was all about what the substance is and not what it's doing. One final point at a general level, and then we'll dive into the authorities themselves. My learned friend is very keen to limit these EU cases to their facts, and one can see why. But there's a difficulty with that at a very high level of principle, which is that the whole point of the preliminary reference procedure is that it gets used as a sort of judicial helpline, if I can put it informally, on points of law. It pronounces only on principles of the relevant EU law, and it doesn't apply them to particular sets of facts. In fact, it has no jurisdiction to do so. That's then left to the domestic courts. So a submission that this is just a finding about a particular set of facts is prima facie troubled, because that's just not how the CJEU system is bound to work. And these are all preliminary reference decisions, of course, because the EU authorities don't have any granting power in respect of these rights. So none of them are appeals from EU bodies. They're all preliminary reference judgments. So they're all stating principles of law. So we should look at those principles and see how they extend to these facts, not simply ask, has somebody extended them to these facts already? So with that, I promise we will now look at the authorities themselves. I said we'd work from Abraxas. That's in tab 1. And without wishing to sound bossy, I wonder if it might actually help if you took that out of the file, and we'll keep that to one side and use that as our guide as we go through each of the others. So we can start. If I can just ask you to read paragraphs 3 to 5, just to get the context of what Abraxas was about.
Hang on while I get a script to hold it together. Right, 3 to 5.
3 to 5, please. I'm not seeking to draw anything from those. I just want to make sure that I've shown you what the decision is about before I take you through it.
Yes.
Next over the page to paragraph 9, which shows that the hearing officer concluded that NAB paclitaxel consists of an active ingredient, namely paclitaxel, together with a carrier which enables it to be effective. So the point there, which we'll see come up in several of the cases, is that the other thing, that the question was whether it was part of the product or not, was something which was needed to enable the active to be effective. So to paragraph 20, and that starts the analysis of the law, the case law. Paragraph 20 is on bundle page 9. We can see Mr. Justice Arnold's analysis of the Pharmacia case, with which I agree. It was an SPC application based on an MA for cabergoline granted for a human medicinal product in Germany. The first authorization for that product in the community had been granted in the Netherlands, but there had been an earlier authorization for cabergoline as the active ingredient of a veterinary product. So a question was referred at the bottom of paragraph 20, which in substance is whether X for veterinary use is the same product as X for human use. And you can see the competing arguments that Mr. Justice Arnold summarises in paragraph 21. My lords, tab 8 then is Pharmacia itself. And I'm going to just show you the paragraph I think my learned friend took you to earlier. Paragraph 20 on bundle page 188. So the conclusion here, I embrace the way that my Lord Justice Lewison put this earlier on. It follows first that the decisive factor for the grant of the certificate is not the intended use of the product. And second, that the purpose of the protection conferred relates to any use of the product without any distinction between human and veterinary use. So the point here is they're saying use has nothing to do with it, and therefore there's no distinction between used for humans, used for animals. And that's because product had a narrow construction applied to it, and the certificate does not include any consideration of the intended use. It's not the other way up. They're not simply saying we're making a finding about veterinary use and human use. They're saying intended use generally is not part of the analysis of the product. Paragraph 23 then gives effectively the answer to the question, which is repeated in the dispositif at the bottom of the page. And effectively it's simply that X for veterinary use and X for human use are the same product. And that part of what I call the use context wasn't relevant.
No, I mean, in fact, of course, you couldn't have sold the product for human use without the marketing authorization allowing you to do so.
Indeed. So the inquiry isn't what could you sell it for, the inquiry is what was the product.
Yeah.
Simple as that in my submission. So back to Abraxas as our guidebook.
Right. I'm just looking at para 20, which I haven't read for quite a few years. But, the second part of it, when it says the purpose of the protection conferred by the certificate relates to any use, that's referring back to Article 4, which you can see in the preceding paragraph, which positively provides that the protection conferred refers to any use of the product. And that's a completely different issue from what we're now considering, isn't it? It's nothing to do with it.
That's right. So the first part of it is what I'm relying on, what they say about intended use. But my lord, you're absolutely right. Sorry, I should have made that clearer. The second part, it's true, there's no distinction between human and veterinary use, but that's just part of their reasoning relating to Article 4, which is about what can you do with your SPC once you have it.
Well, it puts you in the same position as if you had a patent, doesn't it, more or less?
It depends what the patent says, my lord. If the patent's a bare product claim, maybe not. So I don't want to give that a straightforward yes, but in this case, yes. So, my lords, to Abraxas again, and paragraph 23, which is where Mr. Justice Arnold introduces MIT. Perhaps the quickest way to do this, if I could ask you to read paragraph 23, which just summarises what the case was about, and then again we'll look at the decision itself.
Yeah. So 23, you just asked to read.
Sorry, no, that's right, my lord. So to tab 5 then in the authorities bundle is MIT. And if we look at paragraph 25 on page 106 of the bundle. This case is active plus excipient. And the short finding here was the excipient was no part of the product. In 27, then, if we could look at 27 of the judgment. So a few points to make about this. As Mr. Justice Arnold in Abraxas notes at 25, the Advocate General in this case had advised the court to rule that a broader interpretation be taken, a teleological interpretation, on the basis of exactly the sort of argument that was advanced in Abraxas and similar to the one advanced before my lords, saying this is just the kind of costly innovation the regulation should be protecting, this is jolly good, and so we should be supportive of it and conferring SPC rights. But that teleological interpretation was rejected by the court, which didn't follow the Advocate General's opinion. Secondly, notwithstanding that the excipient was an ingredient that was necessary for the active to act, it was still not part of the product. So a submission has been made, not today by my learned friend, but has been made below on several occasions. Well, with no levodopa and PDI, there's no effect, there's no therapy. Therefore, they've got to be included in the product. That submission failed here and several other times, as we'll see, and is not good in law. So back to Abraxas again, that's all I need from MIT.
You're not saying that in the combination that Mr. Davis is relying on, which is sulfonamide and L-dopa, that L-dopa isn't an active ingredient?
No, I'm not saying that at all. No, it's conceded that all three are. What I'm saying is he can't say because the levodopa and the PDI are required for the sulfonamide to do something meaningful, therefore they must be part of the product. Because that was equally true of the excipient here and of the adjuvant in the vaccine case, the GSK, which we'll see in a moment. But no, I absolutely embrace that there are three active ingredients in this case.
So if I've just understood that interchange,
Yes.
you are saying that the three are active ingredients in the therapeutic effect, but they are not the product.
Correct. They are not the product, the subject of the marketing authorization. They are the product authorized by the protected by the patent, and so they are the product.
Yeah.
This is the difficulty with saying the product is, because my entire case is that in 3A, the product is different from the product on the facts in 3B, and that's why we have refused this SPC. As a matter of principle, the product must be the same in all of those cases. The problem in this case is that on the facts, the product of 3A and the product of 3B are not the same.
Yeah. In short, you say there's got to be a match between the MA and the claim.
Absolutely. And we've all agreed what the claim has as the product. So we've got to say that that's got to be the product of the MA, and I say it's not.
Yeah.
The point that I'm extracting here is you can't say X must be part of the product because without it the other bits don't work. Because that failed here and we'll see it fail again.
Yeah.
So to Yism, which Mr. Justice Arnold deals with at 28, I don't think we need to turn that one up. So I think I can ask you just to read paragraph 30 of Mr. Justice Arnold's summary, actually, which just gives the answer. This was a reasoned order case. My learned friend has taken it to you, taken you to it.
Yeah.
And 31, excuse me, which is much shorter and over the page.
Yes.
Just says they're clear that product is to be interpreted strictly and doesn't include the therapeutic use or even whether it was human or veterinary. This is all of it. I appreciate this is rather dull and that it's repetitive, but that's exactly my point, is that this was a clear and consistent line of law with one exception that we're now going to get to. So now comes that exception in the form of the Newron decision. I wonder if I could ask you to read paragraph 32 of Abraxas, which summarises it, and then I can just dip into the actual decision.
Yes.
I'm grateful. If we can go then to tab 7 is the Newron decision, and bundle page 174, I'd like to look at paragraph 21. That just makes the point that it must be the same product in all of 3A, B and C. Crystal,
Just give me that reference again.
sorry, that's paragraph 21
Of the judgment.
of the judgment indeed, which is
Not
on
the-
page
not the
174,
Advocate General. 21.
tab 7, page 174.
Yes.
The first 3 conditions it begins. So this just makes good the point that the same product must be found in all of 3A, B and C. And D for what it's worth, but they don't say that here. If we can turn over the page and just look at paragraph 27, it gives the answer that articles 3 and 4 must be interpreted, in this case, as meaning that a veterinary MA for that product doesn't preclude a human MA for that product being the basis for a new SPC. So this is a flat contrary to what we've seen.
Yes. Different conclusion from the Pharmaceuticals case.
It's a 180-degree refinement. My Lord, Mr. Justice Arnold sets out two problems with that in paragraphs 36 to 38 of Abraxas. Which essentially says this was a bit of a sudden about turn. It's a bit puzzling to me to know what it means for the rest of the law on this point. So, my Lord, that's the excursion. I wonder, I'm going to spend a fair bit of time on Santen. We've done those very quickly. That's the excursion from the line of case law, Newron, and so I propose, if that's a convenient moment, we can restore order by looking at Santen after lunch.
Right, all right, 2 o'clock. So how are we doing for time, as a matter of interest?
I'm doing fine, I think, as far as I can see. I was on my feet when I expected to be, and I'm making good progress, so I think I would not expect to be, I would hope to be done in an hour after lunch. That may be a little ambitious, but it won't be by much.
Thank you very much. 2 o'clock.